Good morning, everybody. I'm not Phil Brandt. I'm Bert Garland from Ogletree Deacons, and welcome to This Week at Work.
This Week at Work is the only show about the workplace that offers you front row seats and a microphone featuring experts in human resources and employment law to bring you practical, timely, and accurate insights so you can more effectively lead your organization. It's Thursday, October 12th, episode 252. In 2023, employers witnessed a flurry of changes at the state and federal levels. In the dynamic landscape of employment and labor law, staying up to date is not just a best practice, it's a critical necessity for employers nationwide. Today, we'll delve into the heart of one crucial aspect of workforce management, your employee handbook. Christine Cruz from AIM joins us to offer tips, and perhaps more importantly, some traps that employers simply can't afford to ignore when updating their employee handbook. And as always, we welcome your questions, comments, and opinions on anything and everything affecting you this week at work.
Good morning, everyone. First, I want to take a quick moment to say that, I've said it before on the show, that technology is great, but it's great only when it works. And our co-host here, Phil, is having a little bit of technical difficulty this morning. So I am here this morning to introduce the program. I'm not going to interview myself or anything. Luckily, we have a guest on today, and that's Christine Cruz. Christine joins us, and she's going to be here to talk to us today about employee handbooks. We know that the Phil is going to be down in Florida a little bit later this month, and they teased the guests a little bit over the past few episodes, who will be presenting with some of the presenters at AIM's Wayfinder Summit coming up on October 27th. Andrew Adeniyi, who was on the program, I believe that was last week. Wasn't that, Nick, or am I losing track of time?
That was 2 weeks ago. Last week was Ryan Kohler, and we talked AI, and Andrew was talking the circle of leadership.
Yep. So speaking of Ryan Kohler, he'll also be there as well. And then there will be a legal update. Unfortunately, it's not being presented by me, but somebody else down in Florida. And then speaking of Florida, we're very excited, like I said, to welcome back to the show Chris Cruz, who brings a wealth of knowledge regarding employee handbooks and keeping them current. Welcome back to the program, Chris.
Thank you, and good morning, everyone.
Good morning, Chris.
So there's Nick. I appreciate that, Nick. So, one thing I want to say real quickly is I broadcast, everybody knows that about this time last year, I broadcast from the city of Jerusalem on a beautiful sunny day in front of the Western Wall. And I just want to acknowledge that this has been personally one of the toughest weeks of my life. And with that said, I think we'll move on. It's just been very hard to pay attention to things going on in the world. But rest assured, we do have Lawyer on the Clock today. So, Nick, if you're ready, let's go with Lawyer on the Clock.
Oh, now see, when you take the seat of the host, you have it's in the bylaws that you have to forget to introduce the polls. So what I'll do is I'll do you a favor, and I'll go ahead and introduce the polls today.
Thank you. You wouldn't have thought I might have done that on purpose, would you have?
No, not at all. All right. So question number 1, do you have a separate procedures manual for supervisors or managers that give guidance on how employee handbook policies are administered? So we're looking if you have a separate manual of how they are administered. Question 2, if you operate in multiple states or municipalities, well, that's hard. How are handbooks maintained to reflect differing laws in those areas? So we do have an option if you do not operate in multiple states or municipalities. But if you do, we'd like to get some more details on that from you. And
those are two very, very good questions. And I know Chris will have a lot to say about those as we get into those polls. Now, with that, Nick, are we ready for Lawyer on the Clock?
I suppose we could do that. All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so we've got a couple of topics I want to cover today real quickly. I'm not going to spend too much time going through all of the facts of the case, but this is a case that I mentioned before on this program. And yesterday, the city of St. Louis, through its legal counsel, submitted a 66-page brief to the United States Supreme Court, arguing that the Supreme Court should not disturb an Eighth Circuit ruling that a female police sergeant's lateral job transfer did not amount to gender bias. The city of St. Louis argued that changing the federal bias law standard would allow courts to micromanage the American workplaces. This case arose from a case that started in 2018, where the plaintiff in the case, her name is Jatanya Muldrow. She brought her case in Missouri State Court in August 2018. It was removed to federal court that December. She alleged that after the arrival of a new supervisor, she was removed from a prestigious intelligence division and placed in a different department where the work was more administrative. And she argued that happened to her because she was a woman. The Eighth Circuit, which is our court of appeals that covers Missouri on the federal level, the Eighth Circuit affirmed summary judgment in favor of St. Louis in April 2022, ruling that the plaintiff had not shown that the reassignment imposed a quote-unquote significant disadvantage since her pay and rate didn't change. So the Supreme Court agreed to take up the case in June after the request earlier this year. The Biden administration weighed in on whether lateral transfers can serve as the basis for the bias claim. In an August brief filed with the U.S. Supreme Court, the plaintiff in the case, Muldrow, argued that the Eighth Circuit added words to Title VII that fly in the face of lawmakers' intentions, and that the quote-unquote significant disadvantage standard should be scrapped. So this case is going to have far-reaching impact for employers across the country, because again, the Supreme Court is likely to decide what constitutes an adverse employment action in the discrimination context. Does it really need to have a change in the material terms and conditions of employment, such as employment itself, pay, supervision, benefits, or can it be something less, such as just a not as desirable job assignment, even though the material terms and conditions did not change? So again, a very, very significant case that the Supreme Court will be deciding. At some point, what will happen now is that the plaintiff in the case will get to file a reply brief to the Supreme Court, and then the Supreme Court, almost with guaranteed certainty, will set the case for oral argument, and the Supreme Court will then make its pronouncement on where the law stands on that issue. So that's the first one I have for you. The second one is not entirely unrelated. Nick, I'm going to put you on the spot here, see if you've been paying attention. I've mentioned before that Title VII, that covers discrimination in the workplace at the federal level, there's one specific word that's not covered in Title VII, or not used in Title VII. It appears nowhere in Title VII. I'm really putting you on the spot here, and I'm going to see if you know the answer to this question. What word never appears in Title VII of the Civil Rights Act of 1964?
I am going to go with it depends. No? It depends doesn't work?
Check your
How
chat.
about harassment?
Check your chat.
How about harassment,
which
I feel like I'm experiencing right now?
Yeah, sorry about that. Well, you are exactly right. The word harassment actually never appears in Title VII of the Civil Rights Act of 1964. The word discrimination appears in Title VII, but the word harassment does not. Harassment is a form of discrimination. And so the courts have said that Title VII did not need to use the word harassment because harassment in and of itself is a form of discrimination. And so not content with what the courts have said, the EEOC on October 2nd published its proposed guidance entitled Enforcement Guidance on Harassment in the Workplace. That guidance was initially proposed in 2017, but stalled during the change in political administrations. The new proposed guidance reflects changes to the law that have occurred since that time, though the EEOC is very quick to note that any final guidance document will, and I'm going to quote this, will, quote, not have the force and effect of law and are not meant to bind the public in any way, end quote. But again, if the EEOC is putting this out there as guidance, they're hoping to drive the agenda and get the courts to follow what is in this harassment guidance. So the first, I'm going to cover just some key provisions, and then we'll move forward with our guest. But the first provision is pregnancy and childbirth. So sex-based harassment includes harassment based on pregnancy, childbirth, lactation, etc., as well as a woman's reproductive decisions. So that's the first area that they're saying harassment can be in the form of pregnancy harassment, childbirth, lactation, etc. Sexual orientation and gender identity. In light of the Supreme Court's 2020 decision in Bostock versus Clayton County, Georgia, the guidance provides examples of discrimination based on sexual orientation and gender identity, such as intentional and repeated misgendering, as well as the denial of access to bathroom or other sex-segregated facility consistent with the individual's gender identity. This one, I can tell you, if they move forward with this, this will one day end up in front of the Supreme Court. There are cases right now, and the law seems to be holding out there that it would be an infringement on people's First Amendment rights for the government to tell people that you have to use a person's specific pronoun. So that's where the courts seem to be going right now. Two more points. First one is virtual harassment. With many employees working remotely, virtual harassment is actionable and includes comments made during a video meeting, racist imagery that is visible in an employee's workspace while the employee participates in a video meeting, or sexual comments made during a video meeting about a bed being near an employee in the video image. And these words come from this guidance. I did not make that up. So to me, these are things that are already included and covered within Title VII, but the EEOC nevertheless wants to make it very clear that such comments would be in violation of the law. And then finally, social media. Electronic communications such as texts or posts on social media can constitute harassment if they impact the workplace. The guidance further states that it is increasingly likely that the non-consensual distribution of real or computer-generated intimate images using social media can contribute to a hostile work environment if it impacts the workplace. So anybody who wants to provide feedback to the proposed guidance, we really don't have much time to do that. Comments are due to the EEOC by November 1, 2023. So stay tuned and we'll see if that guidance actually becomes effective. It's a little bit later this year. And then if the guidance does become effective, we'll wait for the EEOC to start enforcing the guidance and then seeing what happens if these cases end up in court. So that's what I've got today for Lawyer on the Clock. And hope that's been informative to you. And I think with that, what I'd like to do now, even though it's a little bit awkward here, is I think I want to take a quick look here and get to our Employers Lounge and our poll results. So the topic today is, have you updated your handbook recently? We all know that
Nope.
AIMS Wayfinder.
That is not
Yep.
a question we have today. That was in the it was in the pool of possible questions. The two questions that we do have, if you're wanting to look at it, is, do you have a separate procedures manual for supervisors that gives guidance on how employee handbook policies?
Hey, Nick, I know that's not the poll. I'm just asking the question, have you updated your employment
Oh, I have
handbook
not
recently?
I have not. Oh, you're asking
All right.
the audience. I'm sorry. I thought this show was all
Yes,
about me.
exactly. So we've talked about the fact that we know that AIM is holding its Wayfinder conference down in Florida pretty soon, and there's excitement of the technology AIM has injected into its Florida operations. They have resources available to help employees with employee handbooks, and one of those resources is in fact Chris Cruz. Chris, welcome to the program this morning, and thanks for joining us.
Thank you very much, Bert. I appreciate the introduction and your update on what's happening in the world of employment law court cases. So today's program is going to focus on updating handbooks. And I'm going to address this first poll question because Bert and I had a conversation prior to the program starting about, do we have a separate procedures manual that gives guidance on how employee handbook policies are to be administered? And the reason I asked that question, and we're asking that question, is I've seen far too many handbooks that get into minutia and detail that don't need to be in there. They're addressing specific guidelines as to, for example, Bert, as you pointed out, how we're going to investigate a claim of discrimination. And that detail doesn't need to be in a handbook. It's going to be discoverable. Even your procedures manuals can be discoverable. But Bert, why don't you share with me what you spoke to me about prior to this starting?
Sure. So, Chris, and I appreciate that. So you and I, what we chatted about is that let's say that an employer gets a complaint of discrimination or harassment. And if that employee handbook contains all of the minutia and the detail on how an employer is going to commence an investigation, what's going to happen is that eventually, if you end up in court or you end up in depositions, a plaintiff's attorney is going to pick apart every aspect of that procedure that you as the employer did not follow. It is simply enough for you as the employer to have in your harassment and discrimination policy a statement that says when a complaint of harassment or discrimination is made, or frankly any other complaint, the employer will investigate. And that's simply all you need. You don't need to start getting into this is how the employer is going to investigate. We're first going to sit down and interview the person who's been affected by the harassment and discrimination. And then once we do that, we're going to sit down and we're going to go over video evidence and computer evidence. And then we're going to interview everybody who the person says witnessed this. And then not only that, we're going to interview everybody in the whole company. And, you know, you go on, the procedure could be endless. And every complaint of harassment and discrimination is its own animal and needs to be treated as such. You cannot lock yourself as the employer into a rigid mechanism of what's going to happen when a complaint is actually made. Chris, what are your thoughts on that?
Absolutely. I absolutely agree. In terms of handbooks, procedures, we want to give the employer as much flexibility as possible in administering and making decisions based on their policies. So we don't want to lock ourselves in to something that we down the road can't follow or fulfill.
And
yeah,
actually,
and perfect.
Yeah,
Go
I was
ahead.
going to ask a question here, Chris, since really coming off of that. So you can't cover everything possible, right? That could happen. So, you know, one of the things we're curious about is, can you address an issue with an employee if it's not covered in the handbook? Does that leave you out in the blue?
Nope, absolutely you can address those issues, because I am never surprised by the creativity employees can use to push the boundaries of our standards of conduct and behavior and professionalism. So, for example, in all the handbooks I've reviewed, I have never once seen a statement that says, "Thou shalt not spread feces on the bathroom wall or floor." Yet at least once or twice a year, I get a question. We have someone who's spreading feces on our bathroom wall or floor. Okay, we don't have handbooks that address those specific issues. We don't have handbooks that have policies that say, you and your coworker can't go into your car in the company parking lot at lunchtime and have sex. Yet here we are dealing with those issues.
I don't know. That sounds Florida specific to me.
Yeah. I don't know, Bert. I'm guessing you probably fielded some of those questions too.
Yeah. Well, Chris, I mean, that's why in every employee handbook, I do recommend that employers have an anti-species spreading policy in there specific. Yes. No, I'm kidding, of course, but I think you're right that the handbooks need to be broad enough and have certain sections that that capture those types of misconduct in the workplace.
Absolutely. That's why we say in our rules of conduct, includes but is not limited to. Again, we want to give the company flexibility. Language. Yeah. Right. So
exactly. So Chris, real quickly, what should employers be concerned about with respect to their handbooks right now? What's going on right now that employers need to be paying attention to?
Well, right now we have had a lot of legal changes in both federal and state laws throughout the country. So, for example, earlier this year we had the Pump Act that passed. And it's surprising how many employers don't even have in their handbooks a policy regarding lactation breaks. We need to address that. We have the Pregnant Employee Workplace Fairness Act that passed earlier and went into effect back in June. So just as we tell our employees that if you need an accommodation under ADA, come discuss it with HR. If you need a religious accommodation, come discuss it with HR. I think we probably need language in our policy to talk about if you're pregnant and need an accommodation, come talk to HR. And we also have a National Labor Relations Act board that if we've been in HR for a period of time, they have issued recent board rulings from the National Labor Relations Board similar to those that were issued probably around 2012. And they're strictly interpreting our handbook policies and are wanting to make sure that our particular policies, especially around confidentiality, personal conduct, conflicts of interest, harassment, don't chill an employee's rights under the National Labor Relations Act. So under President Obama's NLRB, we saw similar board rulings. And now under President Biden's board, we again are seeing similar rulings that may affect some of the policies that we have. Bert, do you have any comments on that?
Yeah, I think those employers who revised their employee handbooks back in during the Obama administration and then scrapped those employee handbooks during the Trump administration are wise to consider dusting off those Obama era employee handbooks and using that as sort of the starting point and then updating it with these new laws that you mentioned, Chris. So, so that's kind of my thought on that. Chris, what are some of the traps that you see out there right now? Some of the don'ts that employers should be wary of, in addition to making sure their handbook is not full of procedure.
Okay, well, one of the first issues, and it relates to our poll, is if we're operating in multiple states or multiple municipalities, we want to make sure that our policies address any specific laws in those areas. So I'm happy to see that in our poll results, our polls are showing that for those employers that operate in multiple states, multiple municipalities, they have specific policies that address those differing laws, those differing ordinances or state laws. The other thing so I'm happy to see that in terms of a due and what we want to see included, we want to have a statement in our handbook that handbook is not a contract. we want to retain the right to change policies, wages, benefits, and working conditions. And I believe, Bert, you were explaining to me that when you have draft acknowledgements for employee handbooks, you like to see 3 or 4 separate acknowledgements. Can you tell me about that?
Yeah, so most employee handbooks that I run into have a single acknowledgement. And that's the general handbook acknowledgement that I acknowledge I have received this employee handbook and that it's my obligation to read and understand the contents of the employee handbook. And if I have questions about the handbook, I will address those. And oh, by the way, this handbook is not an employment contract. You are an at-will employer. And that's sort of the general employee handbook acknowledgement. And that's important because it gets the person to acknowledge several things. Number one, that it is their burden to read the employee handbook and understand it. And number two, it gets that potential contract issue out of the way, that the employee handbook is not a contract of employment. It is a handbook, and it's meant to inform employees of the policies of the company. It's not meant to create an employment contract or change the at-will nature of the employment arrangement. So that handbook acknowledgement is obviously very important. But there are two or three other acknowledgements that I recommend being included in a handbook separately from the general acknowledgement. And that is because there are 2-3 areas where employers are most likely to face litigation. And those areas are, of course, in the area of harassment and discrimination, what I was talking about initially on the program today. And so I like to have a separate acknowledgement of the employer's harassment and discrimination policy. And the reason for that is that that policy places several burdens on the employee, namely the burden for the employee to make a complaint, or if they see harassment and discrimination taking place, they have to bring it to the attention of the employer. And so I want the employee's acknowledgement on that document so that if I'm sitting across from them in a deposition someday or in trial, and they say, well, my employer threw this 40-page handbook at me when I signed up for employment and told me I needed to read it, but I didn't really read everything closely. So I didn't really read this harassment discrimination policy. It is much easier for me then to take out that separately acknowledged harassment and discrimination policy and then ask the employee, now, isn't it true that during your orientation, your employer actually presented you with this separate policy and you read it and then you signed it, correct? And it makes it much harder for the plaintiff to avoid saying that they didn't know what was in there. The second area where you're highly likely to end up in litigation with employees is related to confidentiality as it relates to the employer's confidential, proprietary, and potentially trade secret information. And so every employee who works for an organization should have an obligation to maintain the confidentiality of their employer's confidential, proprietary, and trade secret information. And then third, the last acknowledgement that I would want in there, if you are an FMLA covered employer, I would want a separate acknowledgement of the employer's FMLA policy. And again, the reason is exactly the same as my reasoning for wanting that separate acknowledgement on the harassment and discrimination policy. And that is, I don't want an employee coming back to me down the road and claiming ignorance about what was in a specific policy. And again, since those are the policies you're most likely to end up in litigation over, I do recommend, even though it is an administrative burden, I do recommend having those separate policy acknowledgements. Christine, I'm curious about your thoughts on that.
I agree. I think it makes perfect sense to me. And I think for all of us, for all employers, we should be, first of all, during orientation or whenever we roll out a new handbook, I think there needs to be a briefing with our employees, specifically directing them to those, that non-discrimination, non-harassment policy, our FMLA policy, our confidentiality rules, all of those. I think we need to make that part of our rollout of our handbooks. I think we need to make it part of our orientation when people are onboarded. So I think that makes perfect sense. And certainly we want as employers, we want to make it as easy as possible for our employment law attorneys to defend us when, not if, a lawsuit occurs.
Yeah, that's exactly right. Not if, but when. Well, Chris, I can't thank you enough for participating today and providing us your valuable insights on employee handbooks. AIM does employee handbooks. You could see a little promo on the screen about what AIM offers to its members regarding employee handbooks. And know that most the employment law firms also do employee handbooks. Not that we're trying to compete with AIM, but we do have a little bit of a different focus from a legal review standpoint. And so AIM offers some really advantageous pricing to get an employee handbook jump started. And even after AIM does a handbook, you still may want to have it submitted to legal counsel for review in any particular jurisdiction in which you're operating. So
I just may add in there for our audio listeners that because we're showing this little pamphlet, the handbook promotion that AIM is doing, and one thing that they can't see is that to take advantage of the discount, there's a phone number. It's 314-754-0236. It says 314-754-0236, and can get. I think there's different packages they have available.
And with that, we are wrapped up with our program. Stay tuned next week. We're going to have Jim Plunkett from my firm's Washington, D.C. office on to give us an update about all the goings on in D.C. And there's, of course, a lot. And so we will see you next week at 7:30 Central Daylight Time. And until then, go out and be good.
with the finger point. Love it.
Thank you.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.